Hello students, in this video we are going to start from the civics portion of your syllabus. We are just left with two chapters, chapter 4 and chapter 5. So we will be finishing both the chapters, and then after that we will move on to the history portion. So here we'll start with chapter 4, the Supreme Court. Coming to the Supreme Court, first of all, let's see what is it all related to. It is, as you can understand by the name itself, Supreme Court or the court is related to Judiciary Department of the government. We have three parts of the government, and that is the legislative, the executive and the judiciary. The legislative is obviously the parliament. We have already done Lok Sabha and Rajya Sabha. The executive are the people, those who try to execute those rules which are made, and they are the president, the prime minister, cabinet, council of ministers, all of them. That we did in chapter 2 and chapter 3 respectively. Next we move on to chapter 4 and chapter 5, which are the related to the third part of the government, and that is lawmaking body, and that is the Judiciary Department. So here let's quickly read. Under our constitution, the judiciary is a single integrated system of courts for the union and the states, with Supreme Court at the apex. So that means for the union government, for the state government, we do not have separate judiciary systems. For judiciary system, in terms of judiciary system, we have all the union, all the state, all of them coming together under one particular head, and that head or the apex body of the judiciary department is basically the Supreme Court. So Supreme Court, we'll see. By the single integrated system, we mean the following things. It is given in your book. You can see your books along with me so that you have better understanding when I'm reading as well as explaining. First thing is, the Supreme Court is the head of the entire system. That means entire union government, state government, everywhere, all the states, everywhere, all the judicial part, that will be looked after by the Supreme Court. So that means Supreme Court is not going to be personally viewing all the reports and everything over there, but they are all answerable to Supreme Court at some point or the other. So that is why Supreme Court is the highest authority and looking or taking care or supervising all the authorities under its you can say under the country, within the borders of the country, any place, any, you can say, union territory or state or any particular region, they will all come under Supreme Court. Next is, there are no separate sets of laws, and a single civil and criminal system operates throughout the country. So you cannot say that this state has separate laws for them or they have different rules and regulations. When they are under one particular judiciary system, that means every state, every union territory, every city, every town, every region is going to follow the same rules and regulations. The intensity of some rules might differ from each other, but basically the rules are going to be same. Next is, all cases coming from the lower court can be taken to the higher court and ultimately to the Supreme Court. So as we know, Supreme Court is the highest authority, so it simply means that all the cases coming from different places, different regions from the smaller courts, they will keep on. It is just like the drip down method. It's just the vice versa. It is coming upwards from the lower courts to the higher courts, and then higher courts to the high court itself, and then from high court it comes to the Supreme Court. So that is how all this particular formation of the thing is done in a proper order, and after Supreme Court you cannot go any further higher, and because the simple reason is Supreme Court is the highest authority. Once you have got a decision from there, you have to abide with it, you have to stick to it, you have to follow it. Next we see need for a single independent judiciary. Here it is given the heading as single independent judiciary, but the title is a little different. It should be single integrated judiciary. Why is it required? So now the thing is, India opted for this single integrated system of judiciary, and the reason being, like many of the places, unlike the double judicial setup in USA, we are following single one because of the following reasons. First is, in a representative democracy, administration of justice assumes special significance in view of rights of individuals which need protection against executive and legislative interference. So over here we have a representative democracy. That means many people have been, many different regions, many different communities, they are represented over here. So we cannot have different particular rights for different, otherwise that will cause more of a disparity and chaos in the country. So that is why everyone we accept everyone to be different, but when they come under judiciary, they will be all treated alike, they will be all given equal justice, so that even in the diversity we can have the unity. This protection is given by making the judiciary independent of the other two organs, and this is done by legislative and executive are not included in it, so that is why they cannot influence the justice given to the various people, communities. They are totally, judiciary department is totally free from all these particular departments. Second point is, an independent and supreme judiciary is also an essential requirement of a federal government. In federal setup, there is a constitutional division of powers between the executive, legislative and judiciary. So federal setup has a different executive, different legislative and different judiciary setup. So it is very important to keep it separate from the executive and the legislative department, because while legislative makes the laws and it passes on to the executive to make it implement properly, we can see implementing and making of the laws are very closely connected. But when it comes to punish someone for not following those rules and regulations, or punishing them as per the rules and regulations, that's a totally different office, and that is why it requires to be remain separate from these two departments. So that is why we have tried, not we but the country has tried to keep it away from the other two departments, independent from the other two, any influence of the other two departments. Next is, an independent and impartial judiciary is an essential requisite for ensuring human rights and protecting democracy. That is the reason, because if we keep it away from the other two departments, any particular, you can say, this influence is not there on the judiciary department, then in that case proper, you can say, justice is given, proper human rights are implemented, and proper protection to the democracy is also provided by the judiciary office. Next we move on to now the proper department of judiciary, and that is, we are going to start with the highest authority, and that is Supreme Court. So here let's see the Supreme Court. The important things we are supposed to take up in the chapter, which you are going to answer, which you might be questioned again and again. So first is composition. When we talk about composition, Supreme Court consists of a Chief Justice, the highest authority in terms of judiciary department, with Chief Justice of India, and there should not be more than 30 judges, other judges, until Parliament by any particular law prescribes for some more number of judges to be given over there. So it is only the Chief Justice and the other 30 judges. Remember, we are talking about judges, we are not talking about the lawyers. We are saying 30 judges plus a Chief Justice. What are the qualifications for the judge of a Supreme Court? A person is not qualified or appointed as a judge of the Supreme Court unless he has, obviously he is a citizen of India, he should be a citizen of India. Besides that, has at least 5 years a judge worked as a judge of High Court or of 2 or more such courts in succession. So should have been a judge of High Court at least for 5 years. Otherwise, should have been an advocate in a High Court for nearly 10 years, for minimum 10 years. So 5 years a judge, or maybe 10 years a advocate. Or, in the opinion of the President, a distinguished jurist. Now sometimes a person might not be having a 5 years of experience of being a judge in the High Court, or maybe he doesn't fulfill the qualification of 10 years a lawyer in the High Court. So in that case, the Chief Justice or other people are not going to make any particular decisions or changes. It is at that time the President who thinks that this person is a jurist, a very good jurist, and that is why, believing on his particular capabilities, a president can even give such a person a chance to be the judge of a Supreme Court before he finishes or completes that qualification which is required. So that can be done only when the president interferes. Next is appointment. Every judge of the Supreme Court is appointed by the President of India, and it is only in the consultation of the judges of Supreme Court and of High Court. So Supreme Court judge is appointed when by consultation of the other judges, those who are already there in the Supreme Court, along with that some of the important judges of High Court also, besides the Council of Ministers. In case of a judge other than the Chief Justice, the Chief Justice of India shall be consulted. So in case of a judge, a Chief Justice is also asked, and his consultation is taken, and his suggestion is also taken. So that means we can say he is also consulted. When the Chief Justice is unable to perform the duties of his office by, maybe you can say, for any reason, he is absent, or because of the death, or because of the incapabilities or illness or sickness, then in that case the President may appoint another judge of the Supreme Court as the acting Chief Justice. So that is also done only by the President. It is not done by the the other judges of Supreme Court, that they decide, okay, somebody can be the Chief Justice. It is not decided by them. It is decided by the President. Here we are talking about the acting Chief Justice. So let's talk about more of the appointment of the ad hoc judges. Now, when we are talking about the ad hoc judges, here what's the difference between an acting judge and an ad hoc judge? Let's see. Acting, we don't have a judge, we have acting Chief Justice. It is the highest authority, and acting Chief Justice means that everybody knows he will be there only for a small period of time. He is just a substitute. He might or he might not be taking the position. Basically, he is just filling the gap for the time duration. So it is for sure that he is not going to be there. But when it comes to ad hoc is basically that for a longer period of time they are going to substitute. They are not substituting a particular person, they are basically filling up the gap, and they don't even know who they are substituting for. Many times in the ad hoc, they themselves are the one who fill up the place later on. So in that case we can say Chief Justice may appoint a judge of a High Court as an ad hoc judge of the Supreme Court for a period as may be necessary. Such appointments are made with the consent of the President. So ad hoc judges are given a proper appointment for a particular time period that can be extended or that can be decreased, but they are given a particular appointment, and that is given by Chief Justice in consultation with the consent of the President. So they are properly working over there for a particular time period. So it is not that some particular person might come back to his position and the ad hoc judge will go back. It is not like that. It is that ad hoc places are those places for which there has been no particular appointment made as yet. So to fill up that particular gap, these people are taken for a time period, but they are not permanent in their posts, in their job. And then later onwards, when a proper you can say vacancy comes out for that particular, filling that particular post, then even they can apply, and they are given moreover a preference that they had worked over here for such and such time, so they might be preferred to take that to be given that particular place. So that is the thing. So we can say ad hoc is basically those places which are not permanent jobs, they are temporary jobs, and they are just filling up the gaps till the time the real vacancy or real job comes out for that particular position. Then we see term of office. A judge of Supreme Court shall hold office till he attains the age of 65 years. He may also resign his office by submitting a resignation letter to the President before his tenure comes to an end. Or a judge of Supreme Court cannot be removed from the office except for his proved misbehavior or any disrespect to the Constitution. But that cannot be done instantly. For that you require a 2/3 majority of the members of the House present and voting for such a removal. This procedure is known as impeachment. So we can say that the judge of a Supreme Court can be impeached. Most of the executives are impeached. So in the similar way, even the judge of a Supreme Court also can be impeached. Next we see the seat of a Supreme Court. Supreme Court, where does the Supreme Court main authority sits, or where is the Supreme Court? So we can say the Supreme Court shall sit in Delhi or in any other place as the Chief Justice may decide with the approval of the President. So they can be in the other places also, but that can be done only by the approval of the President, and for that Chief Justice have to give a legitimate reason why they want to have the Supreme Court sitting over there, or why they want the Supreme Court to sit at a particular place wherever they want to shift it. So that can be done, but only when the President agrees to it, approves to it, and a Chief Justice makes a proper legitimate reason for that particular thing. Now with this we come to the end of this particular module, this particular part. Later we will do in the next video independence of judiciary from the control of executive and legislative. In the beginning we saw 3 points how judiciary is kept away from legislative and executive. In this particular next video, we will see what are the things that have been done to keep judiciary away from from legislative and executive, like the appointment of the judges as well as removal of the judges. What are the things which are done in the judiciary separately without any particular interference of the executives or the, you can say, legislatives. So that we'll do later onwards. Plus we will be doing the jurisdiction and powers of the Supreme Court. So these two topics we will be catching up in the next video, the following video. So with this we come to the end of today's video. I hope you have understood it. Please go through this particular chapter. When you are seeing this video, I would suggest that you take your books with you, go through those books, and while I'm explaining, you do look into the videos. It's no point just looking at the video. You can take this, it's an educational video, there is no entertainment over here. So you can just simply look at the video and listen. You can just simply hear the video, listen to it, and look into your books. So that will be like a better explanation for you to understand. So with this we come to the end of the module. I hope you have understood it.